Hi, everyone. Welcome. We'll give it about a minute and then we'll get going. Thanks for joining us today. All right, we have got too many slides to wait, so we're going to jump right in. Hi, I'm Michelle Bodian. You've tuned into the Vicente webinar. If you're in the wrong place, sorry, but you're stuck. You got to listen to us anyway. Today's topic, intoxicating and synthetic hemp regulations, rolls right off the tongue, but we're looking to do just an update on state legislative session. Those who have tuned in, we did one of these webinars last in December. A lot's changed since December, very fast moving topic, so a lot to cover today. Just brief agenda, going to go over who we are. We've got some special guests from Colorado and Vermont. Very excited to hear their war stories and get updates on their programs. Going to kind of hit on state updates, then give a little bit of a federal update. Spoiler alerts, no big movement there, but we'll talk about where we are, some federal predictions of some of the bills that are moving slowly, and what we might see coming up out of the Farm Bill. And then there will be time for questions and answers at the end. If you have any questions, please use the Q&A button on Zoom to put in your questions. And then for everyone that always asks, this will be recorded, this will be sent out, and a copy of the PowerPoint will be sent out. So move on over for panelists to introduce themselves. I'll start with myself, Michelle Bodian. I'm a partner on the East Coast office of Vicente, and I am co-chair of our hemp and cannabinoid practice. That is kind of what I like to say my day job, but that is supplemented by New York and Connecticut cannabis licensing and regulatory. I'm going to invite my colleague Andrea to introduce herself, and then we'll get to our exciting special guests.
Thanks, Michelle. I'm an attorney in Vicente's LA office. I provide regulatory advice to cannabis and hemp companies on a wide range of matters, supply chain issues, cannabis compliance, marketing and advertising, and a variety of state and federal regulatory matters.
Great, thank you. And then might as well start alphabetically with the state. Jeff, would you like to introduce yourself?
Sure. Thanks, everyone. Good morning or good afternoon, depending on where you're joining us from. My name is Jeff Lawrence. I'm the director of the Division of Environmental Health and Sustainability at the Colorado Department of Public Health and Environment. A lot of words there. Basically, we do oversight of all things food in Colorado. In 2018, there was a decision to make hemp fall into the food and dietary supplement sector within Colorado, and that's within our realm. So we've been involved with hemp regulation and oversight over the last 5 years.
Great, thank you. And then last but not least, Brynn.
Hello, everyone. Great to be here. My name is Brynn Hare. I'm the executive director of the Vermont Cannabis Control Board, and that's the state regulatory entity that has jurisdiction over cannabis and hemp-derived products. So glad to be here.
Great. And speaking of Vermont, I think you're up first. Would love to hear a little bit about kind of what Vermont's been up to. You have taken a unique approach to regulating these products, and love if you can bring everyone up to speed of kind of how you ended up here, rulemaking, what the current lay of the land is in Vermont.
Yeah, absolutely. So you can skip to the next slide, which is where I'll get started. This slide kind of provides a little synopsis of the testimony that the 2022 legislature heard that sort of summarized the concerns about hemp-derived products that were appearing in Vermont. So adult use cannabis has been legal in Vermont since 2021. And this is a summary of sort of the caps that we have in place in statute right now. So single serving of an edible is 5 milligrams. Package is capped at 100 milligrams. And then that we actually have a percentage of THC cap on flower and on solid concentrates also. And then I think probably everybody attending this webinar will be pretty familiar with what the federal definition of hemp looks like in practice when you're talking about hemp-derived products. So in Vermont, as in most states, there's really a growing interstate market for these unregulated, intoxicating, or psychoactive THC products that are derived from hemp. And, you know, purveyors of these products can sometimes exploit this loophole in the federal definition of hemp, typically by converting the precursor cannabinoids found in hemp into THC or a psychoactive analog of THC. And alternatively, some manufacturers are extracting hemp or extracting THC from hemp that's naturally occurring at pretty low concentrations, concentrating it, and then reintroducing the THC concentrate onto hemp flower or some other product, which is creating kind of the functional equivalent to cannabis. So these products are widely sold in Vermont gas stations and garden supply stores where consumers might mistake them for regulated, state-regulated adult use cannabis products. And meanwhile, these hemp-derived products aren't subject to any of the testing protocols or the packaging or labeling or advertising requirements that are set out in statute for adult use cannabis, and also, concerningly, are available to people who are under 21. So given that this sort of contravenes the entire intent of creating a regulated cannabis market in Vermont, the legislature was justifiably concerned. You can switch to the next slide. And as a result of their concern, they punted the oversight of these products to the Cannabis Control Board. So originally, the Agency of Agriculture had jurisdiction over hemp growers and hemp manufacturers. And given the Cannabis Control Board's testimony on the concerns about these hemp-derived products, they decided that the Cannabis Control Board was more appropriately situated to oversee and regulate these products. So you can see that by statute, the Cannabis Control Board has the authority to regulate synthetic cannabinoids and hemp-derived cannabinoids, including Delta-8 and Delta-10. So once the board had, and this is a good slide, you can stay here. Once the board had jurisdiction over these products, we decided to initiate emergency rulemaking as a stopgap measure to really protect the public until we could take the conventional rulemaking path. So in Vermont, the Administrative Procedure Act allows that an emergency rule can be adopted if there's an imminent threat to the public health, safety, or welfare. And significantly, this is really only an interim measure. An emergency rule can only be effective for up to 180 days. So it gives the agency time to take the conventional rulemaking path while the emergency rule is in effect. So, as the slide notes, the administrative process for this emergency rulemaking path is really greatly reduced. The Legislative Committee on Administrative Rules can object based on the basis that the rule was not sufficiently necessitated by imminent peril. But the Cannabis Control Board made a finding at their last board meeting by a declaration that a real emergency exists. And that finding was that unregulated products that contain these synthetic cannabinoids imperil the public welfare, and therefore they adopted the emergency rule that I'm going to go through in just a minute. Because before this emergency rule, we really didn't have the authority to do anything about these products, these intoxicating products that were on the shelves, as I talked about earlier. So given that was really undercutting the work of our adult use licensees that are selling Vermont grown products, they took this sort of emergency action. So you can go to the next slide. So the goals for the emergency rule are to remove these unsafe products or products with unknown safety from the market, and limit the intoxicating products to the adult use and medical market, and to promote Vermont's local hemp businesses and give Vermont cannabis consumers access to safe and regulated products. So you can skip to the next slide. So it's the position of the board that intoxicating or these intoxicating products or products that contain synthetic cannabinoids shouldn't be available to consumers until they're evaluated for safety. So as we do for our adult use market, we have a product registration system in which we verify that all products that are available for retail sale in Vermont are made by product manufacturers that are licensed by the board, that comply with testing requirements and follow manufacturing standards. and comply with packaging requirements, including requirements for child-resistant packaging and a prohibition on plastic packaging. And then also requiring that these products be subject to adult use cannabis taxes. So if you go to the next, the last 3 slides I'm going to pop through are the actual emergency rule. So the section emergency rule 1 is the prohibition. And the main targets of the rule are isomers, variants, analogues, mimetics of delta-9 THC. And that would sweeps in the familiar delta-8 and delta-10, and also delta-9 cannabinoids and any chemically manipulated intoxicating cannabinoids, like, for example, the HHC, no matter where they come from. And you can, so those are prohibited products. If you skip to the next slide, emergency rule 2 sets out the presumptions. So in order to operationalize that prohibition in emergency rule 1, we created these 4 simple presumptions. So first, so a consumable product that is not cannabis or a cannabis product is presumptively prohibited regardless of the delta-9 THC concentration of any plant from which the product is sourced, if the product in the form offered to consumers first contains a total THC in a concentration that exceeds 0.3% on a dry weight basis, or it's also presumptively prohibited if it contains more than 1.5 milligrams of THC per serving. And per serving is sort of defined as the amount that would be reasonably ingested by a consumer in a single instance. Or it's also presumptively prohibited if the whole package contains more than 10 milligrams of THC, unless the ratio of CBD to THC is at least 20:1. And that provision is put in there to protect full spectrum products that really are not the sort of target of the board's concern. Or lastly, the product is presumptively prohibited if it has the dominant market appeal of mimicking the intoxicating effects of THC. So lastly, on my last slide, there's a few exceptions. So this prohibition, this rule shall not apply to any product that's been evaluated by the board and registered as a cannabis product. As I mentioned before, the board has a product registration system. And so if we review it and determine that it's safe and register it, then it is not prohibited. Also, it's not prohibited for medical patients. It may be appropriate for the board to approve specific products that it finds appropriate for use by a medical patient. The board has statutory authority to allow for the sale of products to patients that may be otherwise prohibited in the adult use market, if the board makes a determination that the product would be appropriate for a patient. And then lastly, the rule also doesn't apply to FDA-approved legend drugs that are on the market, like Epidiolex and others. So it does not apply to those. And that is it. So that's the emergency rule. And that's sort of the path that the board took to get there. We are currently in the process of amending our adult use cannabis rules. And we are incorporating the emergency rule and maybe some additions to that rule into our existing rule through the rule amendment. So hoping to have that conventional rulemaking done by the end of the summer.
Thanks. And just a couple questions before we move on. Is there going to be a opportunity for public comment during the adult use cannabis, official regulation process, so people would have the opportunity to comment on these regulations?
Yes, absolutely. In fact, I should have mentioned that the board has taken sort of a hemp tour of the state over the last this week and also next week, going on a listening tour to hear from stakeholders about the emergency rule. And so all of the feedback that we're hearing during that hemp tour will be considered and perhaps incorporated into the conventional rule once that gets going. We've also had a number of public comment sessions on not only the hemp rule, but on other aspects of our rule amendment. And that typically the most feedback we hear is about the emergency rule. So the process of turning this emergency rule into a conventional rule involves quite a bit of public feedback.
Great, and I think we can hand it over to Jeff, but just to preview, I did see a question come in regarding enforcement. So I think we'll have time at the end to pick Brynn's brain about how this is kind of rolling out in practice, for those that are currently operating in this space, but we'll save that to the end. And for now, compare and contrast with what Colorado is doing.
Thanks, Michelle. Thanks, Brynn. You heard a lot of specificity in Brynn's because of the emergency rulemaking. Ours is going to be about the legislative process that just passed, and then the rulemaking that will be forthcoming. So in some areas we don't have as much specificity, but I'll walk through where I can in general terms, and then obviously, as time allows, fields questions. Reviewing the attendee list, see a lot of our Colorado industry partners and regulatory partners on the attendee list. So hope they can jump in as well to provide clarity where questions arise. So we had a bill that passed this last year's Senate Bill 23-271. What that was an output of continued conversations from a previously legislatively passed bill that created a task force that allowed our Marijuana Enforcement Division and our folks at CDPHE to get together with industry stakeholders and interested parties to formulate how do we deal with intoxicating cannabinoids and what do we do with that. So the next several general bullets and my add-ons in just verbalization will go over what came out of 271. It revises the definition of a hemp product. As we all know, one of the bigger loopholes within the Farm Bill and the extrapolation of that cultivated hemp definition to a hemp product definition was the use of the 0.3% THC as an allowed threshold for products. Our definition gets into greater specificity about what is allowed within a hemp product in milligrams, and I'll get into that definition specificity in a moment. It also establishes a new registration to allow for this production and export of safe harbor hemp products. Again, we'll get into greater specificity and the impact of that in just a moment. It clarifies rulemaking authority between us and MED to prohibit the manufacturing and indoor production of synthetic and semi-synthetic cannabinoids. The definition that Brynn went over through their emergency rulemaking of what is defined as a synthetic cannabinoid in Vermont, I believe is real close to what we have in statute. And it does prohibit in the bill the production, manufacturing, distribution of synthetic cannabinoids unless rule in coordination with us and our partners at the Marijuana Enforcement Division provide rules that allow for that. So it's currently prohibited by law. It also creates 3 classes of cannabinoids: non-intoxicating, potentially intoxicating, and intoxicating, and has definitions of what cannabinoids are included within those and what are not. Next slide, please. So one of the main elements that came out of the bill is there's about 12 different areas where it gave us very broad and comprehensive rulemaking authority to deal with the current state, and I think more importantly, the advanced state or where the next stages of the industry go. As we all know, a lot of times the regulatory groups lag behind industry. Industry ability to innovate is what allows them to maintain, business and to continue to move forward. And we always are responding to that. While there will continue to be those innovations in the industry that may create regulatory challenges for us, I don't think we will then have to go back to the legislature to seek authority to deal with that. We would probably, if it creates the need for emergency rulemaking, which we already have that authority, we'd have to go through that. So the lag time to deal with new issues of public health concern won't be as much for us in Colorado, I think, moving forward, because we do have that broad and comprehensive rulemaking authority. To be specific, in one area of the statute, it provides us the authority to promulgate rules for the fair, impartial, and appropriate implementation of this section. That's pretty broad. Not a lawyer. We have a few on, and I'm sure a few in attendees, but that gives us a lot of authority to be responsive to the issues we may identify. As I mentioned, it created a new definition for hemp products within that. Instead of saying 0.3% THC, it puts a ceiling of 1.75 THC per serving on that product. We also, and I know there's a lot of debate about this, paired that with a ratio of CBD to THC. The logic that we utilize behind that, and I know there's differing studies on this, was that a higher ratio of CBD to THC mitigates the THC the impacts of THC. And so we have a paired ratio to that. Again, the ceiling of 1.75 of THC and a ratio floor of 15:1 of CBD. We also have created an age gating for certain product types of you must be 21 or older to obtain those products. That is dependent on the amount of THC and the ratio of THC within that. Basically, anything above 1.25 milligrams of THC and a ratio below 20:1 would require age gating. Anything above that would not. There are some specific exemptions for product types that would not have to adhere to the 21 or older, but that's the basis for it. It also provides us a much more definitive description of what's considered an offense in Colorado, what you can and cannot do. In the previous laws, we had some real generalizations of what could or could not be done, and there were some limitations to that or ability to navigate around that if someone wanted to produce products that we weren't comfortable with, but did we have the clear authority to deal with that? The offenses section is much more definitive now and allows us to be more responsive to folks producing products that we're not comfortable with or don't believe should be consumed by the public. One of the main things as well is it significantly in the law increased our penalties provision to hopefully deter bad actors. Any industry has its good actors and bad actors, so not making a disparaging comment about this industry compared to others. But really what was occurring is business decisions could be made to be non-compliant with our law or regs based on the revenue that could be generated because the penalties just didn't deter that. Penalty provisions now are $10,000 per day per violation. So it changes the landscape for a business to sit there and say, I know I'm going to willfully violate the law here, but I can do so and the revenue stream outweighs the penalty cost. I don't think that's the case anymore. And to the biggest issue that was created within the law, or the biggest area that had debate both within the task force itself and then at the legislature, was the creation of a safe harbor allowance. In general terms, as it says here in the bullet, it allows for the production of products here in Colorado to be exported to other states as long as the other state hasn't specifically prohibited that product by state statute. So a product can be made here that, say, a Delta 8 product, and it could be exported to another state, and we would not see that as being non-compliant with our state law. We do have a requirement that they adhere to all the governing regs for production, which we incorporate by reference the federal GMPs for food and dietary supplements. So it doesn't go unregulated, it is regulated. The significant difference is that we say, hey, that product can't be sold in Colorado, but if the other state hasn't prohibited it, it can go there. With that, we've also will by law for registration of these facilities require an attestation that they assure that they do the due diligence to make sure that the products that they're producing and distributing are allowed by that state. And we're working through that right now. On the first slide, you saw that the effective date of this bill was June 7th. So that was all of 8 days ago. So all the bullets that you see here and the activities that we're going to be engaged with are just ensuing at this time. And we'll be engaging with stakeholders over the summer as we promulgate rules that deal with a lot of these elements of the bill. And we'll hopefully have new regulations in place and by the first part of 2024 and have an ability to implement the intent of the legislation in a way that is more protective of public health. So that's all I have, Michelle.
Great. So what I'm hearing is you'll be back in 6 months on our next webinar to update on the rules. That was my biggest takeaway besides the substance.
Thank you. Yes, it sounds like I've been asked and told. I will.
Perfect. So that is 2 states. We have 14 more to go through. This was a very active legislative session. Obviously, not all states are out of legislative session, but a number of states' calendars up their state house were on, on a January to June schedule. And we're trying to hit on not all, but pretty much all of them today. Might only be a speed read, but rest assured you'll get a copy of this PowerPoint after the fact, but we want to leave times to quickly touch on feds and questions at the end. So with that, I'm going to be quiet, and Andrea and I are going to quickly speed date through all of the state updates.
I love that. Yeah, I'm going to power through these, starting with A's, our Alabama. Alabama's Senate Bill 66 was enacted May 3rd and will go into effect August 1st. This bill creates a broad definition for psychoactive cannabinoids, which are defined to mean cannabinoids derived from or found in hemp, including but not limited to Delta-8 and Delta-10 THC. Now, read plainly, this definition of psychoactive cannabinoids appears to include all hemp-derived cannabinoids, not just those that are generally understood to be impairing. So under the new law, psychoactive cannabinoids, including AKA all hemp-derived cannabinoids, are permitted for sale to consumers that are 21 plus. Next slide, please. Arkansas's Senate Bill 358, which passed in April, makes significant changes to Arkansas's hemp laws. Among other things, significantly, the law does two things. It prohibits the sale of any THC produced by isomerization, as well as wholly synthetic THCs. Secondly, and more importantly, it amends the definition of industrial hemp by providing that industrial hemp cannot contain more than 0.3% Delta-9 THC in the hemp-derived CBD on a dry weight basis. So that's Arkansas, at least the notable parts of Arkansas. Next slide, please.
And then I think I'll jump in Connecticut, and I'll add, I should have added some disclaimers at the beginning of running through these states. I mean, we heard in Colorado and Vermont, subject to further regulation, subject to guidance. So in a lot of these are freshy laws, so laws that have been newly passed. So we're waiting for the agencies to issue guidance. We expect going through rulemaking, so a lot more information, and some of the questions might be answered as they, new laws start getting implemented. So the disclaimer that this is mostly black letter law, and there might be some additional information to come from it. With that disclaimer in mind, Connecticut, we have a new public act. It was an omnibus cannabis bill that does a lot of things to the adult use medical side of things, but importantly creates a new class of high THC hemp products. These new products, if you exceed the milligram limit, which I believe, next slide, we should hopefully list. If you exceed the milligram limits, this would be considered cannabis products, and cannabis is in marijuana and needing to go through the regulated adult use market, manufacturing, retail sales, all of that good stuff. So in Connecticut, new definitions and new THC limits. The limits are based upon the product type: edibles, topicals, transdermal, tinctures, concentrates, and then any other new products, since everyone's innovative in this industry. If it's not one of the above already named, it does have a catch-all 1 milligram per serving basis or 5 milligram per container. And this is an effective date of July 1st. Next slide. Kentucky, this was signed in March, but has some emergency rules that we are expecting to see no later than August 1st. And I do encourage just a plug for public comments. A number of states either currently or proposed will have some rulemaking. And it's great to provide your comment and feedback in our webinar here, but more importantly, to provide it to the state and to the regulators actually implementing the regulation. So please, my plea to everyone, utilize the public comment period. So Senate Bill 544, like I said, signed in March. Rules to be expected in August 1st. And it does, some of these states are not all prohibiting. Some states are expressly allowing under certain conditions. Kentucky, the outlier, permitting the sale of Delta-8 to persons 21 plus. You have some restrictions on where the products need to be sold. So we're expecting to see some testing standards, labeling standards, all of that good stuff to come in the regulations, but setting a path forward to get these products into the hands of consumers. Next slide. Maryland, their adult use implementing bill, so the Cannabis Reform Act was signed by the governor on May 3rd. It went into effect immediately. We do anticipate emergency regulations that will come out and be effective July 1. A draft of those are available, but essentially they mirror the existing law that's already in effect and doesn't provide too much additional information. But again, another state setting a milligram limit. Anything above that milligram limit would be considered cannabis and regulated under that program that's being set up presently, 21 plus. And in Maryland, enforcement, I just want to flag, is not with the Maryland Cannabis Administration, formerly the MMCC. Enforcement in Maryland will be governed by the ATCC. So knowing which agency's website to check to know where guidance is coming from is usually your first step in this. Next slide. All right, Andrea, kick it back to you for some more M's.
Yep. So as many of you know, Minnesota just became the 23rd state to legalize adult use marijuana. The new law will also regulate hemp-derived products, including topicals, lower potency hemp edibles, and hemp-derived consumer products. The new regulatory framework for hemp-derived products goes into effect March 1, 2025. So prior to March 1, 2025, hemp products are subject to the existing regulations that govern the sale of these products that are contained in section 151.72 with some additional notable requirements, including one, beverages are now limited to a maximum of 2 servings and may contain a maximum of 5 milligrams of any THC per serving. Similarly, edibles other than beverages may contain a maximum of 5 milligrams of any THC and 50 mg of any THC per container. Retail sellers of lower potency hemp edible products must register and obtain a license by October 1, 2023. Minnesota does have a good FAQ on these lower potency hemp edible products, and the link is in the slide. And of course, it's fairly easy to find online as well. Next slide, please. Also notable with Minnesota's new adult use law that includes this hemp regulatory framework, it includes definitions for artificially derived cannabinoid and synthetic cannabinoid. As you're seeing, these definitions in each state are kind of a little bit all over the place. But that is the state of play at the moment. So as you can see here, artificially derived cannabinoid is a cannabinoid extracted from the plant to create a different cannabinoid or another chemical compound, including THC. And synthetic cannabinoid is a compound that's not extracted or derived from the cannabis plants. Artificially derived Delta-8 and Delta-9 are permitted in edible products, but hemp products cannot contain synthetic cannabinoids as defined. Next slide, please. Montana. So Montana House Bill 948, signed by the governor also in May, similar to other states, sets a milligram limit for cannabinoid containing products. It's a low milligram limit. Hemp products may not exceed 0.5 milligrams of THC for each serving and may not exceed 2 milligrams per package. HB 948 also amended the definition of hemp to explicitly exclude synthetic cannabinoids, and thankfully also provides a definition of synthetic cannabinoids. A very broad definition, as you can see, it includes cannabinoids produced artificially, whether from chemical synthesis or biosynthesis, including using yeast and algae to create cannabinoids. Next slide, please. And back to you, Michelle.
And don't read too much into our back and forth. There was no rhyme or reason for our states going back and forth. And as you see the underline here, do you want to flag, these are hyperlinked, so you'll be able to find this if anyone wanted some light bedtime reading or wanted to compare the definitions for all of these new laws. So North Dakota, April 24th, signed by the governor, sets limits on THC content, kind of theme throughout this. Many of the states are not only coming up with new definitions, but setting THC content limits and also limiting the use of cannabinoids made via isomerization. So prohibits the sale of hemp and hemp products created by modifying or converting hemp extract into Delta-8, Delta-9, Delta-10, or any other THC isomers. Also generally re-prohibiting hemp-derived products that are not FDA approved from being sold as dietary supplements, food, or beverages marketed with any medical claims. Next slide, please. Oklahoma, another new May law amends the state's Controlled Substances Act to provide that THCs, including any THCs derived from hemp that have been chemically synthesized to emulate THCs in marijuana, are controlled substances. The catch in Oklahoma, though, is that chemically synthesized is not defined. Hopefully, future rulemaking may clarify the types of products, the types of cannabinoids that were intended here to be prohibited as controlled substances. Next slide. Back to you, Andrea, for
I'm on
Tennessee.
mute. Yeah, that lack of definition of chemical synthesis or synthesized is makes things more difficult for sure. Okay, so Tennessee Senate Bill 378, again, signed in May, a little bit more liberal, permits the sale of THC isomers and analogues, including Delta 8, Delta 10, HHC, THCO, and THCP, subject to minimum purchasing age of 21 plus, and THC concentration limits, which I'll note on the next slide. The new law also creates a regulatory framework for hemp-derived cannabinoids, which is a defined term, and specifically excludes topicals, hemp feed products, and the cannabinoids listed here, which are generally known to be non-impairing. Next slide, please. So some of the other notable highlights of the Tennessee bill are that beginning July 1, purchasers of hemp-derived cannabinoid products must be 21 plus, as I mentioned. It sets a maximum THC limit per serving for ingestible products to 25 milligrams in the aggregate of one or more hemp-derived cannabinoids, as again, remember, as that term is defined, and imposes a 5% tax on these hemp-derived cannabinoid products. Next slide. Utah. So this law was signed back in March, but just went into effect last month. In Utah, hemp cannabinoid products may only contain naturally occurring cannabinoids and may only be sold to persons who are 21 and older. Utah prohibits the use of artificially derived cannabinoids, which is defined in the statute, as you can see here, as any cannabinoid compound created by changing the chemical structure of any substance derived from the plant. So it's quite a broad definition of artificially derived. And Utah also sets milligram limits on hemp products as well. Products can contain a combined amount of total THC and any THC analog that does not exceed 10% of the total cannabinoid content, and the product may not exceed 5 milligrams per serving and 150 milligrams per package of total THC and any THC analog. Next slide.
I think I'm up, but just to stay on Utah for a moment, they have issued some guidance. Utah is one of the states that registers individual product SKUs, and they've issued guidance stating that they're not essentially, in layman's terms, going to bounce existing products that don't comply with this. When the registration runs out, they're letting licensees and product registrants know that they would not be re-registering their product, but at least there's a little bit of a undercurrent of a safe harbor to let you sell through existing product that's already been registered within the state, and that's listed on the state's website. So just a plug there for some additional information. I think we're going to just kind of breeze through. Sorry for the end of the alphabet, but want to make sure we get time for questions and touch on the feds. So I'm going to breeze through the next couple of slides, but you'll have them when you get the email blast after the fact. Virginia enacted in April, but effective July 1, you'll see a lot of these bills effective on July 1st. So we got a couple more weeks for those that are making business decisions, selling through inventory, and trying to figure out what just happened this session. So beginning July 1, you see the milligram limits that have been implemented in Virginia, as well as the new definitions. Next slide. Washington, quirky effective date, so signed May 9th, but effective July 23rd. The law will prohibit production, processing, manufacturing, and sale of any synthetic or completely synthetic cannabinoid. We also get some new definitions of hemp consumables, although while it's a defined term, isn't used elsewhere in the law. But given some private discussions we have, this new law does not impact Washington's current prohibition on hemp extract being included as a food ingredient. Next slide. West Virginia, we've got 2 laws that were signed and effective this month, and then amend the Industrial Hemp Act to allow for limited and regulated access to hemp-derived cannabinoids, which are defined as naturally occurring non-synthetic substances, and have a list there, Delta 9, Delta 8, Delta 10. And West Virginia is one of the more comprehensive states in terms of their packaging and labeling, their registration process, and their guidance. So we expect a lot more information to be published and come out of West Virginia in response to these, but we'll give them a courtesy 2 weeks before we start nagging them for all this updated content. Next slide. Just more on West Virginia. This also is one of the 2 states that imposes a higher tax than otherwise. Most hemp products are subject to normal sales tax, but in Tennessee and West Virginia, we saw new tax rates come out specifically related to these product types, West Virginia being 11% retail sales tax. Next slide. And then a couple honorable mentions. I'm just going to churn through quickly. Honorable in the sense Florida, I encourage anyone who's in this space to take a deep dive in the legislative process that was Florida based upon the bills that were proposed versus the final language that's making its way through. For signature, that original first drafts look to prohibit synthetic and intoxicating cannabinoids, the final version not including that language. Oregon, sorry, Andrea, I'm going to just take it from you. They are in some active rulemaking public comment period closing at the end of this month, and there's a public hearing on, I think, Friday or Saturday of this week, and this is related to their definitions for artificially derived CBN products. So I encourage everyone who's in Oregon or sells in Oregon to take a look at that upcoming rulemaking, submit public comments, as well as the existing policy was extended for a certain amount of time. And then in New York, just with everything going on there with cannabis and hemp, they did put an announcement up in early April that the New York Office of Cannabis Management, which has their medical adult use and hemp program, is looking to ramp up enforcement related to intoxicant and synthetic hemp products. They kind of did a FYI industry. We're going to be issuing some emergency rules, but didn't set a deadline on that. We're hearing that those draft rules will be published in time for the July board meeting. That said, one of the board members in New York, the Cannabis Control Board, just resigned today, so that might impact the timing. They need to get somebody reassigned to that board for all things New York. So that was just kind of honorable mention, speed dating. Next slide. Don't go back. We got to go forward to get through it all. Okay, perfect. So that, again, you'll have it. There's a lot to digest there. We're not out of session yet. Some states are still working their way through the various bills. So you'll have to tune in for another webinar to get the final punchline. But moving on to the feds. That was the quick states. So I'm just going to touch briefly on DEA, and Andrea was going to tackle FDA. Which we may have skipped a slide, but either way, Andrea, if you want to jump in and kind of say where we are with FDA's take on these products.
Actually, we have the DEA letters after this slide, Michelle, and then the FDA status. So if we go to the next slide, there we go.
Bear with us, last minute adjustments to the PowerPoint. Okay, I'll touch on these real quick. Like I said, I want to leave time. So obviously we've been touching on state law. There still is federal law governing this, no matter where or what you're selling these products subject to federal law. We do have kind of 2+ letters from DEA. So writing a letter to federal agency saying, hello, are these specific cannabinoids controlled substances? We have responses from DEA, and you see the dates here. They're pretty well spread out regarding Delta 8 THC, THCO, a delta 9 THCO, excuse me, and delta 8 THCO. And then I mentioned there's kind of a plus letter. There is a third letter that's been circulating over the past week. We were hesitant to include it here just yet. It was posted on a Reddit thread with a lot of the information blacked out. Some of the mainstream media has picked it up, as well as our cannabis colleague, Rod Kite. So the letter does exist. It is talking about some additional cannabinoids such as HHC, but we'd like to see the original letter. I don't believe anyone would take the time to Photoshop it, and it looks like all these other letters, but just want to see the original version published before going wide with it. But just letting you know that DEA's position is different than some of the states' position with regard to the legality of these cannabinoids, and they're taking a different approach and different definition, it seems, of synthetic cannabinoids. So just touch on FDA and then we'll hit into questions.
Yeah, this is a webinar in itself. Very briefly, I will touch on this. FDA hosted 3 webinars. They were all the same, essentially, in April and May to explain how it reached its conclusion that it announced in January that its existing regulatory framework for CBD is not appropriate. FDA's determination was based on 2 key factors: CBD's risk profile, and that CBD cannot meet the existing safety standards for food and dietary supplements. In light of FDA's conclusions, it's now suggesting what they call a harm reduction approach. Next slide, please. So this harm reduction approach is essentially a more permissive pathway for food and dietary supplements containing CBD that now exists under the Food and Dietary Supplement Framework. This approach would require Congress to develop a framework that would provide a basic degree of oversight, meaning labeling, minimum testing protocols, cannabinoid limits. Also, such a framework might include segments that don't currently have predictable FDA oversight, like inhalable hemp products, which are generally not in FDA's jurisdiction in the absence of drug claims and in the absence of tobacco or nicotine. Next slide. Oh, I think that's everything. Yep.
Okay, and then we do have a couple more slides about some federal pending bills, but I am going to open it up for questions and kind of start with first question / prediction of a lightning round. Then we'll get to the rest of the questions, but I'm going to ask Brynn and Jeff and Andrea, and I'll abstain because I'm the moderator. But there's been a lot of talk about the upcoming Farm Bill. The 2018 Farm Bill kind of set this framework. We're due for another one. Negotiations have started. I would be curious your predictions, kind of what you're hearing about whether or not there might be, a new definition of hemp, a finished product standard, some type of reaffirmation of FDA's role in this process. So I would ask you to come off mute and take your best guess about what we might see coming up at the end of the year from the new Farm Bill.
I'll come off mute. I don't know if it's the best guess. I think they will maintain FDA's role because of what Andrea just went over and FDA's stance on that. So that would be its approach to products. I think even if they up the allowable limit in the cultivated hemp in Colorado with the latest bill, we've navigated that some with how we define a hemp product. And so I think we're in a decent position to respond to any increase in that, at least on the product side. Other predictions, it's difficult to predict. I think FDA, as folks have seen on this, will continue to be slow in pace in dealing with this. And so I do think it leaves it up to states to deal with any issues that come out of that.
I don't have any prediction that is better than that. Apart from, this industry has really gotten to go with the flow, and I think that another shakeup is probably on its way, and the industry, I think, is going to be prepared for that since they're getting used to it.
Okay, Andrea, any magic insights?
Yeah, I mean, my prediction is that we're going to see the definition of hemp change in the next Farm Bill. I think we're going to see this limit to Delta-9 THC be expanded to all THCs. That's my crystal ball prediction.
Okay. Yeah, we don't have our typical crystal ball slide that we like to have for predictions,
It's
but
purely speculative.
okay. Well, if it turns out to be true, then we can say heard it here
Mhm.
first. But if it's not true, then you didn't hear it from us. Wrong prediction. And I guess we got a couple questions about enforcement, and maybe Brynn, I did give you ample warning that the question was coming, but from the practical, which we get a lot of questions all the time of, the law says X, but what's happening in reality? Is it X? Is it Y? How has enforcement played out, given that you're pretty far along with the emergency rule?
Yeah, so the board does have civil enforcement authority by statute. There's nobody employed by the board that's a law enforcement officer. We don't have law enforcement authority. The governor did issue like a 10-point safety plan that's sort of articulated for the Cannabis Control Board that we have a law enforcement partner in the Department of Liquor and Lottery. They do employ law enforcement officers. So we have like our sort of designated law enforcement agency that provides us with, I guess, backup, you could say, if necessary. So far, it has not been necessary. We have utilized our civil enforcement authority to go into retail establishments that are selling these products that are prohibited under the emergency rule and ask them to remove them from the shelf. And so far, everybody has been compliant. We have issued a couple of notices of violation, which sort of results in its own administrative process that are sort of in play right now. But so far we've gotten cooperation just with our own compliance and enforcement team going out into the field and doing a lot of educating of people, because I think a large part is just that these products have been sort of left unregulated for so long that people don't understand or know that there is an enforcement authority that is responsible for regulating them now. So that's how it's gone so far. I imagine that will change in the coming weeks and months. There may be more to say about enforcement, but so far we're using our authority and it's going well.
Okay, and I guess Jeff, same question for you, given Colorado has always been innovative, is there, I'm sure there was a plan for kind of how to put the genie back in the bottle, obviously Safe Harbor addressing some of that, but is it a similar education campaign as a step one in Colorado?
Yeah, I mean, compliance assistance and technical outreach is always the first step and will be. I think what's good is, as I mentioned in the presentation, more definitive definition of what offenses are and a stronger enforcement thing. I do think that the folks within our Colorado sector that were doing things that we had said weren't wrong were making business decisions in many instances. And I think we've navigated beyond that, or the bill allows us to navigate beyond that. We have a vibrant and a very compliant industry in Colorado, for the most part. So I think we've weeded out, and in fact, it was an initiative and a task force desire to weed out the bad actors. That was the protect public health and weed out the bad actors were their key points. And I think our enforcement provisions are set up to do that. In our current state, when we see products that we're not happy with, or the facility we've embargoed entire facilities. So instead of embargoing product, we cease and desist the facility, and we've taken that action. We still have that authority. Hopefully we won't have to do that in a whack-a-mole fashion, but we'll be able to deal with it upfront through our regulations.
Okay, and then this is a great but somewhat hard to answer / unfair question of, why is there such a dichotomy among states? You see some overlap in definitions, you've seen some commonalities of milligram limits, even if it's not the same milligram limit, but why are states taking such a varied approach to hemp products? I'll give my answer before kind of opening up to the forum. I'd say it just goes back to inherent state rights. These are complicated issues, complicated topic. Every state's market, industry, agency authority, capabilities, just to hit on all the answers everyone else might potentially give, kind of all culminates in the fact that, things aren't like throughout all these states. And I'd also say of the states that we hit on today, of the 16 states that had bills turn into law, a lot of those, this is third round, the fourth round, second round of trying to run a bill and trying to address the topic. Oregon, Colorado, Maryland all had task forces last year. So, we might see of some of these other states, and the person asking the question specifically named Texas, Kentucky, North Carolina, Florida, next year there might be, more of an appetite to address this. Sometimes these things just take time, but I'll open up the forum to my other panelists, if I didn't steal all their answers, as to why there's such a dichotomy right now in a state-by-state approach.
I won't talk necessarily about the dichotomy, because it exists. To say it doesn't would be disingenuous. But I think what is important for anyone to know is we work with all the different states. We have close partnerships and reach out to them. We're not trying to create new regulations in a vacuum. At the same time, as we can all speak to within our different states, there's different political wills and different desires on different commodities that play into all of that. Michelle, you indicated before, put the genie back in the bottle. That's part of this. Obviously, is when you look at allowances for things, trying to bring that back or scale that back can have some difficulties. But I want to assure those that are on the attendees, the 100+ attendees, that we do try to work in coordination with our other state partners. So we're not going way astray from what they've already established, as long as our statutes haven't done that for us, because we can't deviate from the statutes.
Yeah, I would just echo what Jeff just said, that it's part of what makes this cannabis regulatory world such an interesting experiment, is that there's a ton of collaboration between regulators, like our sister agencies in other states. So I think that we do really try our best to be collaborative and utilize the same kind of rational thinking. But it's what makes it so interesting is that states can come out pretty differently depending on culture and politics and other things. So it's been one of the interesting things for me in working in the cannabis regulatory world.
And I know the Cannabis Regulatory Agency, CANRA, is there assuming I believe you both are members, is there a specific working group on hemp cannabinoids and synthetic and intoxicating, sorry, just mash those words up together, a new product type? Okay, so nodding yes. So there is a specific working group of states who are trying to address this topic.
Yeah, and I do think
the magic. Which way are you going?
Well, I was just going to say that subcommittee, I think, has the broadest participation among states. That there's quite a few state participants in that subcommittee, and it seems to be very much a hot topic. It's definitely one of the subcommittees that gets the most participation, and I think that we're always getting updates because there's always something new to be said about what states are doing. So I'm not sure if I could make a prediction apart from sort of what you guys articulated in the state-by-state review. But it does seem like there is some consensus around the per serving and per package limits. Getting closer, at least.
And I would just add real quick to that, back to the other question too, CANRA is dealing with it, but some of the things you see in our statute or you will see in our reg is the next iteration, because if a state did something to begin with, they might have found some frailties with what they thought was the right approach. We learn from that and go to the next step. So that's sometimes why you see the iterations or the differences between states, because one state learned from the other and moved it forward.
Gotcha. Okay. And then I have a specific question for you, Jeff, if you're able to answer it. It's about the safe harbor provision on interstate commerce and synthetically derived THC. And the question is essentially asking, given the 2+ letters we have from DEA, if one of the synthetic cannabinoids is on that DEA list, Delta 8 THCO, would that be something subject to safe harbor? Would they be able to ship out? Or are you cross-referencing your state cannabinoid lists against the DEA, list via letters?
It's going to be dependent really on two things: the definition of synthetic and how the questionnaire is defining that, because we have definitions within our statute, so that will determine. Right now in statute, depending on the definition, we prohibited the production, manufacture, and distribution of synthetic cannabinoids. Semi-synthetic would not be is not prohibited, and we're required to promulgate rules around synthetic cannabinoids, which semi-synthetic, which could be part of the safe harbor provision. So it probably won't have 100% alignment with the current DEA because of our definitions within law, and it will be to be determined based on our stakeholder engagement with the rules and the safe harbor regulations that we have to develop.
Great. And I think we're at time, and apologies. We tried to rush through. I think we were too ambitious with our agenda, but it's not our fault. A lot happened. But if you've got other specific questions, we've included the contact information here. You know, obviously Colorado, Vermont, you've got the experts here. Any other state, happy to try our best to answer or put you in touch with the other individuals. And Jeff agreed live on air to come back in 6 months. Brynn did not object. So I take that as she will be here, and neither have come off mute. So that's basically them agreeing. No, nope. So turn back later for an additional update once we see more legislatures come out of session. Once we see the, you know, the devil in the details of all these regulations, please submit public comments. Please reach out with questions. And thank you everyone so much for attending. You'll get a copy of this to watch over and over and a copy of the slide deck. And thanks, Brynn. Thanks, Jeff, for spending the time with us.
Thank
Thank
you.
you so much.
Thanks. Bye.